Hi, everybody. This is attorney Arkady Frekhtman, and welcome to Last Week Tonight, where we answer your questions and we talk about your comments and your questions. So let us know, what questions you have. This one is actually live. We're live coming from our office. It's about 5 o'clock here in Brooklyn, New York, and so you guys could type something in the comments if you have any specific questions. We'd be happy to answer for you. So let me see, and I'm going to go through. I guess I'll start with some of the comments that we had on our channel. And I see some comments, and I took a few notes from the comments, and I wanted to address them. So the first comment that I remember is from Circumnavigate, and he was saying that he was involved in a traumatic brain injury, herniated disc car accident case, and he was told that his mom and girlfriend are going to get a subpoena because it's a large case. So I guess the defense insurance company lawyer wants to subpoena his mom and his girlfriend and have them testify. And so his question was, what should I do to help them prepare for the subpoena and to perform better and at the deposition? And do you know where I can find what kinds of questions they will ask so that I can prepare ahead of time and help them prepare? And also, is there anything you would recommend to prepare? So I would say, I would say something like that. What you probably want to do is just tell them to, relax, don't get nervous, just get comfortable. And the best thing to do is just have your lawyer speak with them and have them review your deposition. If there's a transcript already of the questions they asked you, because you're the plaintiff, right? Have them read that if they have the time, or maybe have your lawyer just do a quick summary with them, and your lawyer could explain to them. Because usually the questions really boil down into two different categories. Number one, the question will be, what happened, right? Who is at fault? What is the liability? That's one category of questions. And then the other category is, what are the damages? What are the injuries that you sustained? How has this car crash changed your life? So that's the other category. And the way they could talk about that. So if it's your girlfriend and your mom, they should be able to talk about, they might not have been in the car with you, so they may not be able to talk about liability, but they'll surely know what kind of person you were before you got into the crash and how your life has changed after this crash. So they could talk about that. They could talk about, the impact to your life, the types of things you like to do before, just things that you enjoy doing. It could be anything. It could be like, cooking or housework or playing sports or whatever you enjoy doing in your life, and then how that's been impacted. And so they could talk about that. And I think that's powerful. It's really, really powerful to have them. And then later, if the case does go to trial, they could come to court and they could testify to the same type of thing, how your life has changed, how your life has been impacted. And sometimes a witness like that, we call it often a circle of friends or a community witness, right? Because it's people from the community. It doesn't have to be like your girlfriend or your mom. It could be coworker, it could be your neighbor, it could be your friend, it could be anybody, right? But sometimes these people only testify for like 5 minutes, but it's so powerful because the jurors are just people from the community too, right? They're just people who get a summons to come in for jury duty. So these other people, these community witnesses that you call, they don't have any skin in the game, meaning they don't get any benefit, right, from whether the jury allows for a lot of money for you, like millions and millions of dollars, or whether the jury allows for a defense verdict and says, you know what, this isn't worth anything. They don't really care. They're just these community witnesses. So it's very powerful if they're coming to court and they're telling this story of how it's affected you. I think that's very, very powerful. And a lot of lawyers have used that and it's really worked. So I think that's a good thing to do. Okay. Let me see what other questions we have here today. I'm going to see if there's any questions. I see on the YouTube channel, I am seeing some comments here. We're using this new streaming platform, so yeah, sorry about that if it's a little bit, I don't know if it's working properly, but I am seeing some comments here. And okay. Let me see here. Okay. We have another question from Steph Z. And she says, or he, I think it's a she says, I'm currently in the early stages of a premises liability lawsuit against my landlord. And she says that she was showering when a wall-wide mirror, a 6 by 4 foot mirror that takes up the entire wall and is 80 pounds, came crashing down on her, and her 3-month-old son was just outside of the bathtub. And she jumped out and caught the mirror and suffered deep lacerations on her hand and now has permanent nerve damage in her pinky. So that's a terrible, and her son thankfully walked away with some minor cuts. But she says if she didn't catch the mirror, it would have been much worse. And after it happened, they discovered from the other tenants that 4 mirrors have fallen before this one, and that they are only held up by an adhesive that eventually gives way. So I guess like that's a really good case, right? Because the landlord is using this cheap glue, this adhesive, to put up these mirrors in the bathroom. They're these huge 80-pound, wall mirrors, and 4 of them already collapsed. So the landlord now is on notice, right? That's legal notice, actual notice that these mirrors are dangerous. They're actually falling, they're actually injuring people or have the potential to injure people. But for whatever reason, he's not fixing these mirrors. He's just being cheap. And so she's saying they were completely aware of this, and although no one got hurt before us, they never warned anybody about it. Do you think we can recover punitive damages? They are a huge company with billions of dollars in assets across the U.S. I mean, I definitely would try. It's hard to say because punitive damages, they vary from state to state. In New York, I know it's very hard to recover punitive damages, but that doesn't mean you can't. Like usually, if you could show that there's a callous disregard and a willful and malicious disregard for human life, then that could be punitive. Because punitive ultimately is meant to punish the defendant, to say, like, look, what you're doing is so bad that we have to punish you. And the way we punish you is by making you pay money. And if you pay this money, like a lot of money, like millions and millions of dollars, maybe like one day's worth of profits. They did that to McDonald's in one case, or it could be like a week's worth of profits. Now, if you pay this money, now, hopefully that will be a deterrent to teach you a lesson that you're not going to do this again, because this is not something that you can do. Just allow these, mirrors, put them up the proper way. Put a stud into the wall, put them up safely. Well, why do you have to use a cheap adhesive and have them fall down? So, yeah, I think you should definitely try for punitives. If you have a lawyer that's already litigating this and you're happy with them, just have them file for punitives. If you need a lawyer, if you have any questions, feel free to text me. It's 347-566-9595. I'm happy to get on the phone with you and discuss it and, offer you any kind of advice. That's what we're here for. Okay, let's go to the next question. We have a question here from a Blake Woodcrest, and he says, "Hi, Arkady. Super strong information as always. Are you able to do an in-depth video about choosing the right attorney for personal injury? For instance, I heard that insurance companies have a database that shows an attorney's settlement records and how they do. For example, like some lawyers accept lowball offers, never go to trial. And I find that many attorneys simply want to get easy settlements and often work against the client and harp on the weaknesses of the case instead of working up the case." So yeah, he goes into like a little bit of a longer, I don't want to read the whole thing, it's a long, but it's about 3 weeks ago. You could probably find it in our comments. Next time what I'll do is I'll put it up on the screen. I'll put a screenshot of the comment. But yeah, no, I think that's a good point. I mean, definitely what you're saying is true. Like the insurance companies have a database, and the way that they work is the database tells them which lawyers go to trial and which lawyers are not afraid to take jury verdicts. Now, if a lawyer is willing to go to trial, as long as the lawyer has, experience, knows what they're doing, and preps the case correctly, the insurance companies are afraid of the lawyers that go to trial because they know when you go to trial, they can get hit for way more money than they're going to offer you. And so they have that database. They also have a database of actual results. So they know, like, hey, this lawyer went to trial, let's say, 10 times in 1 year, and every time it resulted, this time, hey, he settled the case for $1 million. He got a jury verdict for $2 million. And now all of a sudden they see this is a serious lawyer. We have to be afraid of them. But if the lawyer is just one of those like billboard lawyers that's up on a billboard, he's like, oh, I'm so strong. I'm a billboard lawyer. I'm the, whatever they call themselves, the strong dog or the top dog or the, whatever name, or the hammer. But they don't actually go to court. They call themselves the hammer, but they have the only hammer they have is, the only hammer they have is one of these hammers in their office. So they just sit in their office all day. Forget it. You're not gonna be able to win. And so, yeah, I think the person makes a good point. Like, and I really, that's kind of like what my channel is about. That's what I'm trying to educate people about, is that you have to be careful. So it's hard. It's hard to like really find the right lawyer. But I think that one way you could do it is by researching the firm, making sure that there are jury verdicts that the person has obtained, that the person isn't afraid to go to trial. And yeah, because ultimately, I think what the person is saying is very, very powerful, because if the lawyer is just accepting a lowball offer, then the lawyer is no longer really like a guide and a counselor for their client, but essentially what they're doing is they're making money at the expense of their client, right? The client is the one who's getting the short end of the stick and is getting injured by the lawyer, right? Because the lawyer doesn't want to put in the work, because the lawyer doesn't want to go to trial, but he's forcing the client to take less money. And then guess what the lawyer is doing, right? He's telling the client all the weaknesses of the case, like saying like, oh, we can't go to trial because you had a prior injury, or we can't go to trial because of this reason or that reason. But most of the times, these reasons are just bogus reasons. They're not real, meritorious, substantive reasons. Like, so I really think that that's a good point. This person brings up a good point, and I totally agree with him. But it is hard. Like, it is hard for a client to know that, like, which lawyer is going to go to trial, which lawyer is not. I mean, the only way really to know that is by being able to do like maybe a jury verdict search to see like who's going to trial, who's not. You definitely don't want somebody who's afraid to go to trial and somebody who's going to take a low number. And yeah. So I think that's what he's basically saying. Yeah, he even says that some of these lawyers are getting clients to accept really low numbers, like 3,000, 10,000, and it just really, really low numbers. So that's not good. Okay, let's see what other questions we have here. Let me see. Oh, I see here saying, yeah, I'm seeing a few comments here. Thank you everyone for commenting and for I don't know if I can read all the comments. I can see some of them here. Oh, here's a comment that says somebody hasn't seen a doctor for more than a year, and now the condition is getting worse, so he needs to see the doctor. Will that be subjective? So he has not seen a doctor for more than a year, but his condition that he's suing for has gotten worse. So now he has to see a doctor. I mean, I wouldn't say that's subjective. I mean, subjective is just like what they usually, I just got done doing a trial and we were talking about objective versus subjective a lot during the trial. So the difference is like something that's objective is just neutral, right? Meaning that it's objective in the sense that it's not dependent on a person's complaints. Like, for example, an MRI test, a magnetic resonance imaging, or an X-ray is objective, right? You take an X-ray of an arm. If the arm is broken, it's going to show it's broken. If it's not broken, it's going to say it's normal. So that's completely objective. But subjective is just me saying, like, my arm hurts, right? Now, you could believe me that my arm hurts, so you could say, you know what, the guy's lying, his arm doesn't hurt, he's just making it up. He's a malingerer, or he's a faker, or maybe he's over exaggerating. So that's subjective as opposed to objective. So if you go see a doctor, and the doctor should be able to do all of the testing. And actually, I have a little card here. This is actually a card that I used from my trial. I don't know if you guys could see this. This is interesting. This is actually a card of how a diagnosis should be done, right? So there's 4 parts to a diagnosis. There's the medical history, which the doctor should ask you about your medical history, right? And you tell the doctor about all your complaints, what's bothering you. So that's the medical history, right? Then the doctor has to look at your signs and symptoms, your actual symptoms. The doctor has to do diagnostic testing, whether it's a simple test like the little hammer they hit on your knee to see your reflexes, or it could be a more complicated test like an EMG, an MRI, diagnostic testing. There could be testing in the office. There's a lot of different testing that a doctor can do. And then there's also the physical exam, the actual physical examination. So all 4 of those components, right, all 4 of those make up the pie, and that's like the diagnosis. Then when they give you the diagnosis, it's based on all 4 of those. Now, some of those, of course, are going to be subjective in the sense that you as a client are telling the doctor what your signs and symptoms are, but that's just part of the medical process. And some of them will be objective, like the diagnostic testing, like the MRI or X-ray, as well as the physical exam, different tests they do. So yeah, so I would say that probably that what you're saying is not necessarily subjective. That could be objective as well. Okay. Yeah, let me see what other questions we have here. Here's a question. They say, hey, I'm a big fan. I have a question. After an IME and deposition, how long will a settlement or trial? Case has been going on for 3 years. It's a trip and fall. So yeah, I mean, like basically what I would say is after an IME and a deposition. So usually what happens is first you get the deposition where they ask you questions, right? Like we talked about, they ask you what happened, how did your incident happen, how did your trip and fall happen, what caused you to fall, was there a hole, was there a misleveling, like why did you fall? Okay, then they're going to ask you about your damages. What's your injury from the fall? Did you have a like a broken bone, or where did you go? What doctors did you go to? So that's going to be the part about your injury. And then you're going to go to what's known as an IME, an independent medical examination. Now, remember, it's not really independent. It's a defense doctor. So it's a doctor hired by the insurance company who is, hired by and picked and paid. I always call it picked and paid, right? Because the insurance company picks the doctor and the insurance company pays the doctor. So guess what? The doctor knows who's paying me, the insurance company, the defense law firm. Who's picking me, the insurance company, the defense law firm. Let's think about this. Guess what I'm going to say in my report? I'm going to say that the person's not hurt, right? Because I know who's picking me to do this, and I know who's paying me. So when I did my last trial, in my closing argument, they had this doctor who for 26 years has written reports, and I found like 7,000 reports. In every single report, he was saying, the person has no neurological injury, no neurological disability. I mean, 7,000 times in 26 years. And I was cross-examining him, and he admitted it. He goes, yeah, it's true. So then I said in my closing argument, I said, this is like a jukebox. What do you do with a jukebox? Well, you walk up to the jukebox, you choose your song, first you put in the money, then you choose your song, and then guess what the jukebox does? It plays the song that you picked, right? So that's just what this doctor does. They choose the doctor, they put in money, they send them like, more than a jukebox, probably send them like, I don't know, $1,000 for the exam and report, and maybe then another more money for the actual testimony, maybe like $7,000 for the testimony. And then guess what? What he's gonna sing? He's gonna sing the song that no one's heard. But his question was how long. So I would say for a settlement, I would say probably it could be anywhere from like a few months. It could be like 3-4 months. If everything went well, right? If your deposition went well and the DME was done, then after that's over, they should be able to settle your case. Now, if the case, for whatever reason, can't settle, maybe your lawyer is trying to get really a lot of money, like $1 million, and the insurance company is saying, no, this is only worth like 100,000. Well, now, because you're so far apart, right, there's 900,000 in between, then you have to go to trial. So I would say in New York, at least, after the IME and deposition, to get to trial, it could be still about a year, because once you put a case on the trial calendar, in most places like Queens, Manhattan, Brooklyn, it's about a year wait to get to a trial. Bronx is, I think, even a little longer than that, but Bronx is a good venue where people are getting like $5 million for a small injury. So it's kind of like, sometimes you have a good venue, but it takes a little longer, or you have a little bit of a tougher venue, but it goes quicker. But all, but New York City, for the most part, most of the venues are pretty good. Yeah. And then Ella Dow says, you motivate me to research. Thank you so much. Yeah, thank you. Let me see. Oh, look at this. Somebody says the mirror incident lawsuit you just spoke about is for me. Oh, wow. So that's cool. See, this live thing is working. Like, the people that I'm talking about are actually here. Okay, great. I'm glad that I'm able to help. That's what we're here for. Our goal is helping serious injury victims and their families. So I'm really glad that I was able to help. And, always feel free to text me as well, the 347-566-9595. I'm happy to carve out a time and schedule a consultation so I could speak to you one-on-one and, maybe give you some advice, or whatever you need. I'm very, very happy to help. Okay, let me see, what other questions do we have here? Oh, and she says, what do you think is a fair settlement for a case like this? Well, I'd have to look at the file. I'd have to look at least the medical records or speak with you to find out what the actual injury is. But with a nerve, if it's permanent nerve damage, I think it could be very, very significant. Like, just to give you an example, well, the trial we did last week, the insurance company was offering us $25,000 at first, and they were almost making fun of the case. They were saying, your client only went to the doctor 4 times, right? Because she went to the hospital, she had some stitches, and then it just turned out that she had this complex regional pain syndrome, which is known as reflex sympathetic dystrophy, CRIPS. Very serious condition. But she was like, there's a spectrum, right? So at the very beginning, when you start getting the CRIPS, it's very mild. And so, long story short, we got $535,000 as a verdict because we were able to show the jury that this was a permanent nerve injury, even though it was just to one part of her ankle, going from like the ankle down to the toes, the big toe. But it's a serious injury, and it affected her ability to enjoy life. Like, for example, when a pet, like a dog, would run up to her, she'd have to push the dog away, because if the dog is like, touching her leg, it causes pain. And even when she takes a shower, the shower water hitting her foot causes pain. So we said this shouldn't be happening to a 19-year-old, and the jury believed it. And even though in closing argument, the insurance defense lawyer, and she was a very good lawyer, very, competent, very well spoken, excellent lawyer, but she said, give her $25,000. And then when I went up there, I said, no, this is a life-changing forever injury. This is worth way more. $25,000 is cheap. This is worth, I actually asked for $1 million, but they gave $535,000, which I thought was fair. I thought it was a very smart jury. So, I mean, to answer your question, if you have permanent nerve damage, I think your case should be worth even more than that. I'd have to look at your injury, look at exactly what the nerve damage is, but feel free to text me. I'm happy to help. That's what we're here for. Okay, let's see. Can you refuse the IME if you already have your own doctors and 2 parties are refusing? I don't think you could refuse the IME. You have to do that. That's part of the process. The reason you can't refuse it is because you have all your doctors, right? Whether you have treating doctors, like your doctors that are treating you, or you could also have experts, right? Your lawyer could go out and hire an expert doctor. So you could do both. Now, the insurance company, they don't have any doctors. So the only doctor they get is their IME, or DME, Defense Medical Examiner. So you do have to go. What I also recommend with respect to these DMEs, these defense medical exams, is hire one of these watchdogs. Hire somebody to go there. That way the person is there and they're actually writing down and documenting what these doctors are doing. Because a lot of the time, these doctors are, like, there was this one doctor in New York, actually, this happened a few years ago, where he said that he testified, right? He took the stand, he swore to tell the truth, the whole truth, and nothing but the truth. And he testified that his independent medical exam was 20 minutes. Meanwhile, the plaintiff's lawyer had the actual exam videotaped, and he played it in court. And the videotape showed that the entire exam was less than 1 minute. So he got the doctor lying, and now the doctor never does any more of these IMEs. He got into big trouble. There was a whole hearing. They were going to suspend his medical license. I don't know all the details. It wasn't my case, but it made a whole big thing. And then they said after that, well, why aren't people allowed to videotape these DMEs, these IMEs? We should be able to videotape them, right? To hold these doctors accountable, have them take ownership. If they're going to say that, hey, I did a 20-minute exam, why can't I videotape it to verify? But for whatever reason, the court said, no, you can't. So, but you can't, I mean, in New York, at least, I think you can't videotape these things. But you could send a watchdog, and the watchdog is just an independent person who sits there, and they write down, like, you know, what they did, what they asked you. Because a lot of the times, like what these doctors do is they write the report and they just do everything in a way that's not fair, it's not neutral, and it's just done, everything is done in a way to benefit them. Like, for example, in my case last week, you know, my client was walking or playing in a grass field, and there was a broken, jagged pipe, and that cut her leg really badly. That's what led to the injury. So the doctor writes in his report, your client, what did he say? Your client just fell in the woods. Like, fell in the woods? I even cross-examined him about that. I'm like, doctor, where did you get this from? She just fell in the woods? Is that like a tree falls in the woods? Like, you know, that's what I'm saying. Everything you do is just to minimize your case. Like, you're not, it's almost like it's just terrible. Okay, let's see what other questions we have here. Back fusion, how much is the case worth? I mean, back fusions, again, it's really hard for me to say without knowing, because like, you know, when you ask a question like that, right, back fusion, what is it worth? What you're essentially giving me is like one piece of the puzzle, right? But say this is a jigsaw puzzle. I need all the pieces. I can't tell you what the puzzle will be, or what the answer to the puzzle will be with just one piece. But generally, just very generally, don't hold me to it, but generally back fusions are going to be multi-million-dollar cases in my experience. Back fusions are very serious. So yeah, I mean, back fusions are some of the most serious cases because obviously there's going to be like that arthrodesis device, and it's a serious surgery. So those are million-dollar cases, absolutely. Okay, let me see what other questions we have. Either questions from today, or we could do questions from the comments to our channel. I just wanted to tell everybody, yeah, please, you know, ask your questions on our channel. Just feel free to comment and ask your questions, and that's really good because I read the comments, I respond to the comments, but I also sometimes use the comments as you know, information for this last week tonight. I could answer your questions when we go live or when we do a recorded last week tonight. And then we're also going to do, I know that a lot of people have requested other videos about specific topics, and I you know, I'm very careful about that. You know, I don't just skim over that. I know somebody said I want a fusion surgery after a bus accident. Someone else said about ankle replacements, construction accidents, and spinal injuries after construction accidents, shoulder replacement verdicts. People were asking about this. Somebody asked for dropped foot from a trip and fall. So I have all that written down. So I'm going to do that. I'm going to get to those, but I need a little time to like research that and go into the jury verdict reporter, either it's like Westlaw, Lexis, look at the cases so I can do a good video and answer your questions properly. And we also have that link where you could put in some of your information. So we ask you to please do that. That's really a good thing to do because it's very simple. What you do is you just put in like your name, the facts of what happened, and your injury info. And then what we could do is we could just schedule a consult and answer your questions. So let me see what other questions we have here. Let me see if there's anything in the chat. Let's see here. Yeah, I apologize again because this is a new platform. We're trying to do a stream from this new platform, so I've never used this one before. So I'm seeing some of the questions pop up, but it's not always showing the entire question. It's just showing me like the first few lines. Maybe I have to use this better or learn how to use this properly. Let me see here. See what other questions are in here. Okay, yeah. And then there was one other question I wanted to mention from the chat. I think it was from Mike Richards, and he had asked, let me see here 1 second. Let me see if I can fix this. I don't know if this is popping up on the screen or not. Let me see if I could close this out. I'm not sure if this is like popping up on, I don't know if you guys could see something on my screen or not. I see something popping up, like a question about the back fusion. So I'm just trying to see if, oh, here's another question. Okay, here's a question. It says torn Achilles tendon at a local gym due to cracks in an uneven surface, and the EMS was called to assist. Yeah, so that could be very serious. I mean, if there's any kind of safety violation like uneven surface or a squeaking basketball court, yeah, that could definitely be. I mean, any kind of safety violation, I think, is good liability. But feel free to text me because I'd like to know like where it happened, like what city at least. That way, I could maybe get you a consult with a local partner. But yeah, it definitely sounds like a serious case. It could be you know, high either high six figures, meaning like hundreds of thousands, or it could even get into the millions depending on what the injury is. Yeah. Okay, so I'm gonna fix this later. Sorry about that, because I can't really see the whole comment. I can only see the first few lines of the comment in this streaming app. I've never used this one before, so maybe we'll fix it next time. But let me do one more question before we leave. We're at about the 30-minute mark. And there was a good question here from Mike Richards. It was part of our comments to our YouTube channel. And basically it said, thank you for a brilliant analysis. I have heard of times where a plaintiff in a personal injury case was inaccurate when put under the deposition. The lies, quote, lies or inaccuracies were not intentional, but they didn't hear or understand all the questions that the defendant's attorney asked. So they answered what they thought they heard or misunderstood. It is important to be completely truthful and honest to the best of one's ability. I love your videos, very helpful. They show all of us details we didn't perceive in the past. Yeah, I mean, that's a really good point, what Mr. Richards is saying. That's a really good point, because essentially, when a person answers a question, remember, a person who's giving a deposition, right, a personal injury plaintiff is an injury victim, right? Injury victims are not lawyers. They're not like, brilliant oricians or people or orators or people that understand, how to debate or how to answer questions. They're just, sometimes people, don't even understand what the question is, and they're answering it. So there's a few things you can do. Number one, what I really recommend is prep with your lawyer. Make sure that you meet with your lawyer, that you sit down, and the lawyer really should take time to prepare you for a deposition, because a deposition is a serious thing. Remember, anything you say will be used against you later on by the insurance company and by the defense lawyer. So it's very, very important to understand the question, what they're asking you. What I always say is like formulate the answer in your own mind, like understand what they're asking you and understand what you want to say. And then when you understand what they're asking you and what you want to say, only then answer the question, right? There's no penalty for that pause of a few seconds. So if they ask you like, hey, what color was the car? Okay, what are they trying to find out? They're trying to find out the color of my car. Okay, then you know, okay, my car was blue. Okay, blue. It's like that. Just answer like that. You don't have to say like, there's no extra points for starting speaking and then stream of consciousness, and you don't even know where you're going to go or what you're going to say. So it's always better to take your time. But yeah, I mean, sometimes people do say things that are improper. Like, for example, I think I did a consult earlier this week with somebody, and they asked about a prior injury. And they said, well, have you ever been injured? And the lady said, you know what? No, I haven't been injured, because she didn't remember any injury. But she didn't really have a prior injury. She just had like a little bit of prior treatment or medical condition. Like I go to the chiropractor, sometimes you get a little bit of an adjustment. That's what she did. I think she just went to the chiropractor, got a little bit of an adjustment. And for whatever reason, they believed that that was an injury. just going to a chiropractor, getting an adjustment, whereas it's really not, right? That's not an injury. That's just a like treatment. But the injury really came after the car crash when she had a serious herniated disc, needed surgery. So, but now she's saying that like the insurance company is trying to use that deposition answer against her to, lower the value of her case and devalue her case. So there are ways to deal with that. There are always ways to deal with all of these issues. It's just really a question of the lawyer taking the time to meet with his or her client and then thinking of the best way to deal with the issue. So yeah, but that's a really, really good point, because that depositions, you really do have to spend some time. And but the other thing is, like, sometimes your answer is not going to be perfect. Sometimes your answer is going to be imperfect. And so I think it's good to just be vulnerable, be honest, and just say, yes, you know what, I answered that way. I'm not, maybe I was wrong, because as long as you come off as honest, that's the main thing. What you don't want to do is have the insurance company be able to say, you know what, this guy's intentionally lying, right? Because then it's almost like that goes into the whole thing of tort reform, that they're trying to say, like, oh, there are all these frivolous lawsuits, people are trying to grab money, and people are intentionally lying in order to make a buck. You don't want them to be able to say that, right? Because that'll really, really hurt your case. And hopefully that's not true. Hopefully, so that's what, that's the way I would respond to that. Okay, so thank you, everyone. Thank you for joining us. This was really fun. This was cool. Yeah, we're almost at the 35-minute mark, so I guess we'll call it a day for today. But we'll do another one next week as well. And then, like I said, I'm also going to do the topic videos where I talk about a certain topic, like car accidents, surgeries, different types of injuries, different type of incidents, like different types of accidents and injuries, as well as different types of medical conditions. I'm interested now in this chronic regional pain syndrome, because I just finished a trial about it. So I might do a video about chronic regional pain syndrome, as well as a chronic regional, about that topic, but also some other topics as well. So let us know what topics you'd like to see, and we'll be happy to do some videos about specific topics as well. Okay, thank you so much. Have a great night. Thank you for watching, and we are here for you. Please like and subscribe to our channel, and drop us those comments, because we'll be happy to read them. We'll be happy to answer them, and like I said, we will use that information. We will use the information in your comment for the next Last Week Tonight, whether it's live or recorded, but we'll be happy to use it. So thank you so much, and that way we could really have a two-way conversation, and and you guys can be a part of it. Okay, have a great night. We'll talk to you very, very soon. Okay, bye-bye, everyone.